of Dixon County is now in session. The Honorable Judge Favorable presiding. All ye have business with this court, draw nigh, and ye shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning, everyone. We are ready to begin the sentencing phase of this case. Let's go ahead and bring the defendant out, please. Yes. Thank you. Is there any need for that microphone stand to be up there? All right, ladies and gentlemen, we need to take up a couple of matters before we begin anything in the form of a sentencing hearing. The jury is scheduled to be here, I think, at 11. Is that correct? So that we can address these issues. So I want to first, by giving us an itinerary of what the issues are. Number one, I understand that the state is prepared to go forward with their proof this morning. Is that correct?
That's correct, Your Honor.
And can you give me an idea of what order you intend to present your proofs?
Yes, sir. The state's first witness will be Dr. Lee.
All right. The first witness will be Dr. Lee.
Yes, sir.
All right, go ahead.
The second witness
You need
will...
to turn that microphone. Let Officer Howell turn the microphone on. There's a button down there.
I found the button.
All right, go ahead.
The state's second witness will be Assistant District Attorney Jessica Bourne.
All right.
The third witness will be TBI Agent Nathan Neese.
All right.
And the fourth and final witness will be Lisa Baker.
All right. That brings me to the issue of the victim impact statement. Have both sides been able to review the victim impact statement?
Yes, Your Honor.
Are there any issues regarding that?
There are, Your Honor.
All right, let's go ahead and address those then.
Your Honor, as the court knows, victim impact testimony is, based on the High Court's holding in Payne is intended to, quote, give a brief glimpse into the life of the individual who has been killed, the contemporaneous and prospective circumstances surrounding the individual's death, and how those circumstances financially, emotionally, psychologically, and physically impacted upon members of the victim's immediate family. Payne goes on to talk about how emotional impact of the murder on the victim's family should be most closely scrutinized because it poses the greatest threat to due process and risk of undue prejudice, particularly if no proof is offered on the other types of victim impact. So, Your Honor, I've been provided, and I'm going to pass. I can pass up to the court. I've already
I
shown
have a copy.
Well, I have one that's been struck through with the,
All right.
with,
You want to submit that to the bailiff and?
Yes,
I'll
Your Honor.
review it?
and after Your Honor's review, I'd ask for it to be made an exhibit to this hearing. Your Honor, we have went through and struck through portions of the statement that was provided by the state, specifically stating those portions, it would be our position, A, or it would be unduly prejudicial, generally speaking, because they are directly related to the emotional impact of the murder on the victim's family and requires this court's close scrutiny. The other issues, Your Honor, I would note.
Has the state been shown a copy of those portions that, what you just demonstrated to me that
Yes,
you're
Your Honor.
asking to strike? So.
Yes, Your Honor.
Judge, we're not in agreement with that.
Oh, I know. I just wanted to make sure you knew what Mr. Evans was challenging.
And this is a specific situation where the safe to say the lion's share of the statement, and specifically all of the matters which have been stricken, either deal with issues that go directly to the emotional impact of the murder. There's no real, in the entire statement, there's no real discussion of financial impact or physical impact or psychological impact. It's really, the entire statement really bears on the emotional impact, and I know it's a great emotional impact. I'm not trying to lessen that or belittle it, but in this context, Judge, there are several statements that just aren't appropriate under pain. There's an extensive portion of this statement where Ms. Baker talks about what she addresses the jury directly and tells them why she wants him to be put to death, that she won't give up until he draws his last breath. Those are absolutely inappropriate based on the case law we have before us. So, Your Honor, I've went through this statement mindful of the loss she suffered, and mindful of her right to go before the jury and be heard on that issue, but in protecting the rights of Mr. Wiggins, as I'm obligated to do and bound to do and have sworn to do, and as this court has sworn to do, those items that we have asked to strike are appropriate. They are outside the scope of proper victim impact testimony, and to allow them in would be unduly prejudicial to Mr. Wiggins.
State's response?
Judge, first, the court is well aware of law, as is the state and the defense. These things are not unduly prejudicial. This jury has already witnessed a homicide on video. The statements proposed to be provided in the impact statement are allowed under the law. And Your Honor can give an instruction to the jury as to which portions of the statement should be considered in their deliberations and which should not. But they've seen this video. They know. They know how horrible this crime was, this murder, this execution. This statement should be allowed. And let's also keep in mind, Mr. Evans reflects to a portion of the statement where Ms. Baker asked the jury to put Mr. Wiggins to death. Well, that's the purpose of the sentencing hearing. That's what the state is doing, is requesting that they return a verdict sentencing him to death. Also keep in mind what the jury heard for an entire week in Knoxville from the defense, which was, ladies and gentlemen, our client's life is in your hands, and we're just asking for mercy. This is the opposite of that. Here, we're asking them to not give Mr. Wiggins mercy.
Your Honor, her role here in this portion of the trial is very, very specific. She's not an advocate. That's not how she sits as when giving victim impact. It's not her role to judge potential mitigation proof. There's a large section of this that's been stricken out where she talks about childhood trauma and the potential childhood trauma that Mr. Wiggins' son would endure if he were to be allowed to live. This is beyond the pale. It's not her. Her role is to very limited based on pain. And again, talking about childhood trauma and specifically addressing the jurors, it's not her job to advocate for the death penalty. That's Mr. Crouch's job. That's why he's here. And if you go further down, Payne, or excuse me, State v. Nesbitt, it quotes another case that it relied upon. It said it would be very difficult to reconcile a rule allowing the fate of a defendant to turn on the vagaries of a particular juror's emotional sensitivities with our longstanding recognition that above all, capital sentencing must be reliable, accurate, and non-arbitrary. And what Mr. Crouch is asking this court to do is allow Ms. Baker in this instance to do just that.
This court is well aware of the fact that this case has, for the last 3 years, been a heavy burden on the family members of Sergeant Baker. And this court is also well aware of the law, as I'm sure the District Attorney's Office is also aware of the law that we're required to follow in sentencing for a capital case. Clearly, and I'm quoting now from the State versus Nesbitt, which is 978 Southwest 2nd at 888, and then I think it also quotes from Middlebrooks, State versus Middlebrooks, 995 Southwest 2nd at 558. Admission of a victim family member's characterizations and opinions about the crimes, the defendant, and the appropriate sentence violates the Eighth Amendment. In the State versus Hester, the case that I relied upon yesterday with Judge Alan Wallace regarding the retention of 4 alternate jurors, that State versus Hester case, 324 Southwest 3rd, page 1, a 2010 Supreme Court case, says that testimony that a victim or a victim's family member either supports or opposes the death penalty in a particular case is irrelevant as victim impact and/or mitigation. That's the law that I am required to follow. Allowing the state, some of these statements in that are included within this victim impact statement, I understand that, and I'm going to read those portions that I think will have to be removed from that victim impact statement, not because I particularly want that to be done, but because of the simple fact that the Supreme Court has said I can't allow it. And if I allow it, it constitutes reversible error. And we accomplish nothing by that, depending on what the jury does. It just simply allows for that to be reversed on appeal, and we start all over again. My job is to avoid that, to make sure that the defendant's rights are protected and he's given due process, but also that the state and the victim in this case don't have to unnecessarily go through this more than one time. So I, again, would reiterate that this is standing law. It's not something I am just picking and choosing to enforce. It is the law of the state of Tennessee as espoused by our Supreme Court. Whether I personally agree with that or not is irrelevant. I took an oath to enforce it. So for that reason, of the sections that the defense has asked to be stricken, I will read those portions and I will rule whether or not those portions may be stricken. In the third full paragraph of the victim impact statement, the defendant challenges the following statement by the victim, by Mrs. Baker, that he will never be here to hold her, to kiss her, to watch her grow, to offer fatherly advice, to walk her down the aisle, to meet his grandchildren, to do any of the things that father would, could, or should be here to do. This court finds those statements to be admissible and overrules the defendant's objection to that statement. The defense challenges the following. What I seek from this court is a picture of justice. Although I believe that my husband's death will never be truly justified, there were too many displays of hate and malicious acts for that score to ever be even in my book. What I ask from this jury is to help me protect my daughter, help me protect her and ensure her safety. The only thing that will bring the smallest amount of any resemblance of closure for me is to 100% make sure that this person responsible is no longer able to breathe. I realize that this self-proclaimed monster has a son of his own, and ultimately I'm asking for Stephen Wiggins to die. Some children are better off without a toxic biological parent. That boy should have the opportunity to not be subjected to any childhood trauma. That statement, unfortunately, flies directly in the face of the case law that I have just submitted and the laws, the rules that our Supreme Court has stated. And for that reason, that will have to necessarily be stricken in order to avoid what is clearly plain error on my part to allow it in. Not because I agree with it, the law, but because I believe that is the fundamental ruling of our Supreme Court at this point. The next sentence that they object to is, speaking of childhood trauma, what about my child? What about Meredith? What should I expect or look for her as she gets older? And that could be looked at as effects from her childhood trauma. Should I just expect that her trauma will lead her to drug and alcohol abuse, that she will one day be in and out of jail, that she too could one day ruin someone else's family? In my opinion, the first part of that paragraph, speaking of childhood trauma, is a statement that references what may or may not be evidence at a sentencing hearing of mitigation by the defendant, and therefore it would be premature for that to be brought in, and for that reason the sentence, or those 4 words, speaking of childhood trauma, are appropriate to be stricken. The remainder of that paragraph, in my opinion, again, is an appropriate statement on a victim impact statement, and it will be allowed. The last paragraph of this victim impact statement, that the defendant challenges this portion. I do not, as a mother, ever want her to question that I have done everything in my power to pursue justice and promote change. I too wish to lead by example, and what better case than this to start demanding change. This world we live in and the crimes against law enforcement officers, it's sad. As long as these people continue to get away with these actions because of others continue to look the other way, this world will continue to get worse. So they also challenge the last sentence, I'm prepared to spend the rest of my life making sure yours, Stephen Wiggins, is miserable. However long it may take, you better believe I'm strong enough and I'm not going anywhere. This court's opinion that, again, applying the standard that our Supreme Court has imposed on these types of sentences, it is this court's opinion that the portion of that I've just read, beginning with I too wish to lead by example, would be violative of the Supreme Court's instructions on what we can limit as to victim impact statement, because again it is espousing a particular punishment and a particular advocacy for the type of punishment for crimes against law enforcement. So I believe that sentence beginning with I too believe that I too wish to lead by example, in what better case, all of that paragraph starting with that sentence will necessarily have to be omitted. I do not find that the last sentence, I'm prepared to spend the rest of my life making yours, Stephen Wiggins, is miserable, is inappropriate, and I find that it shall be allowed to be made. Now, again, I'm making that ruling based upon the current prevailing case law and our Supreme Court's instructions to me in allowing victim impact statement. I make this ruling at the beginning of this sentencing hearing so that the state may, in cooperation with Ms. Baker and my ruling, redact the statement that she will be reading to the jury, and then obviously she'll need to read it exactly as is ordered. And then that will, I think, resolve the issue of the victim impact statement. Anything other than with the state's proof that we need to address?
No, Your Honor. We would ask that before Ms. Baker is brought to the stand, that there would be a brief jury out for the court and defense to, again, read the redacted portion and a final agreement on exactly what will be said.
I agree with that, and I believe that is appropriate so that we can make sure that the statement that she's going to be prepared to read will reflect the restrictions that I'm required to put on it. So, all right. Now, having then dealt with that issue, we have two motions that have been filed. But before we get to that, we may want to go ahead and talk about the defense had filed a motion early in the case regarding an aggravating factor. And I believe I have that motion here before me. It was the motion for the defendant to strike the aggravating factor of especially heinous, atrocious, or cruel. I reserve that for ruling, and Mr. Evans, do you want to go ahead and argue that now, or do you wish to wait until after the state has concluded its proof?
Your Honor, not to belabor the point too much, because you've heard a fairly lengthy argument on this motion previously, and you've got the papers in front of you. It'd be our position now, with the proof that's been presented by the state, that the hack aggravator is not appropriate in this case. As I previously argued, for the hack aggravator to apply, it requires that there be something more than that necessary to affect the death of the victim in the case. I cite to several cases in the motion as examples that are well in excess in the confines of analyzing the hack aggravator. They're well in excess of the proof that's been put forward here today or throughout this trial. So for those reasons, Your Honor, we'd ask that the heinous, atrocious, and cruel aggravator be stricken.
All right. General Sagan, you wish to address that?
Yes, Your Honor. Your Honor, as the court is aware, TCA 3913-204-5 states that the murder was especially heinous, atrocious, or cruel, and that it involved the torture or serious physical abuse beyond that necessary to cause the death. And one of the things that we like to start off by noting is in the defendant's motion and some of the cases that they quote, specifically State versus Odom 928 Southwest 2D at 22, I have the cite for this. That case that's cited at the end of the defendant's motion actually refers to a prior statute which also requires depravity of mind as an element, which is no longer applicable to the case at bar. I'd like to draw Your Honor's attention to State versus Carpenter, 69 Southwest 3D, 568, Tennessee Criminal Court of Appeals, 2001, which states that our Supreme Court has defined torture as the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Our case law is clear that the anticipation of physical harm to oneself is torturous so as to establish this aggravating circumstance. That is also from State versus Carpenter at 575. The dread is also seen where she realizes that she will probably not survive the incident. In State versus Carpenter, that was a single blow to the head where the victim realized that she was going to die. That is very analogous to the situation that we have here with Sergeant Baker. Your Honor has now seen the video of Sergeant Baker and heard the medical examiner's testimony. In the video, it's obvious that Sergeant Baker was shot. It was also obvious that he realized that he was shot. Not only did he realize that he was shot, he realized that he was going down. And in those moments, after he has been shot by what Dr. Lee will consider to be a fatal wound, he is radioing in to other law enforcement officers. And he is warning them about what is happening. He is, arguably as a reasonable person might see this, anticipating his death and warning those of other harm to other people. In State versus Carter, it also states that the mental torment is intensified when a victim either watches or hears a spouse, parent, or child being harmed or killed, or anticipates the harm or killing of that close relative and is helpless to assist. Your Honor, we believe that in this case, Sergeant Baker is looking out for I don't really say his family, but his other coworkers who may be placing themselves in peril. And at the time that he is alive, and we do realize that he is also alive, at least for the next 2 series of shots, he is on the ground. You can see him alive and breathing with his body cam on. You can hear him moaning. Medical examiner's testimony was that it is possible that he is also aware of the situation that is going on before the final 3 shots to Sergeant Baker's head. Furthermore, the medical examiner also testified that those final 3 shots were not instantaneous death. This was not an instantaneous death for Sergeant Baker. This was a death that he felt, he realized, he attempted to warn others about, and then ultimately sat there and suffered both physical and mental anguish. This does meet both prongs of what the court must consider. The circumstance of 1-5 does not require a mens rea. The aspect of torture focuses on the circumstances of the killing. The torture prong of I-5 only requires a jury find the victim remained conscious and sustained severe physical or mental pain and suffering between the inflictions of the wound and the time of death. Whether the defendant intended the victim's suffering is irrelevant. But, Your Honor, we know in this case from the defendant's testimony, from the defendant's statement, that Sergeant Baker was suffering. He knew what he had done and inflicted on Sergeant Baker. So we believe that the heinous, atrocious, and cruel factor is applicable.
Mr. Evans?
Judge, what the state is asking the court to do essentially is to rule that in any shooting case where someone is shot more than one time, that the hack aggravator is applicable. And that's not the intention of the hack aggravator. It takes something more. And that's not to diminish what happened. It's not to diminish anything that happened to Sergeant Baker, but it takes something more. And they're asking this court to just blanketly apply it. Those factors, I waited to hear a case from another shooting for her to cite to, where there was multiple shots received by a victim where the hack aggravator was applied, and I didn't hear one. And I probably didn't hear it because it doesn't apply. It doesn't diminish what he went through, but it does mean that the hack aggravator is not applicable based on these set of facts. It is not sound for this court to allow it to go before the jury based on speculative statements from the medical examiner. This type of aggravator is reserved for those where those are clear indications. And the medical examiner, to his credit, Dr. Lee said things like possibly. So in this instance, Your Honor, it's not applicable. We'd ask you to strike it.
Well, as correctly stated, this aggravating factor is, and by the way, it's one of 5 aggravating factors that the state has filed notice of its intent to seek the death penalty. There were 5 aggravating factors. This is one of those 5. And the law does require that for the court to find that should be submitted to the jury, that there be evidence of torture or serious physical abuse beyond that necessary to produce death. In this case, the court listened very carefully to Dr. Lee's testimony, and on his direct examination, it was elicited that the wound that was sustained from the initial gunshot wounds to Sergeant Baker's body would have been fatal because of the severity of them, but that he had the ability for some period of time following that initial shot to walk or run for a short distance, and that's clear from the video of the body cam, that he ran and did make the statement, "Shots fired, officer down." He then collapses on the ground, and you can visibly hear or audibly hear his breathing, and that breathing continues until those 2 are the additional shots that are fired. So in this case, the court finds that the death was not instantaneous from those additional shots, but it would have been it was a fatal shot initially, and that these additional shots, as even stated by Mr. Wiggins in his interview, were shots that were above and beyond what would have been required to terminate the life of Sergeant Baker, and that, in fact, the defendant says he did it to put him supposedly out of his suffering, which indicates to this court that he observed the officer suffering and fired into those last shots directly into Sergeant Baker's head in order to finish the job, so to speak. They were shots that would be above and beyond what was necessary to accomplish the killing of Sergeant Baker, because the medical examiner had already opined that those initial shots were fatal, having severed his aorta. But he also testified, Dr. Lee did, that Sergeant Baker would have had some consciousness and awareness between the first shots and the last 3 shots. And that, in my mind, is if he's lying vulnerable on the ground after he has collapsed and is approached by Mr. Wiggins, who then fires those shots, that Sergeant Baker would have had the awareness and consciousness at that point to understand what was about to take place. In keeping with the cases cited by the state and my own investigation of the case law on that particular enhancement, it is my opinion that it is in fact supported by the evidence, and therefore the motion to strike that aggravating factor will be respectfully denied. All right. Then the only other thing we've got to take up this morning will be both sides have filed, as of yesterday, motions to strike the testimony of the expert witness of the other. The first one I believe I received is the state's motion to strike the testimony of the defense witnesses, and will allow the state, since my recollection is that was the first one filed, will allow the state to argue their motion, and then we will pick up the defense's motion to strike the testimony of the state's witness. That was state filing number 55, state's motion to disqualify the defense mental health mitigation experts. So Mr. Wyatt, you filed it. You wish to argue it?
Yes, Your Honor. Your Honor, the motion speaks for itself. However, I'm going to take the opportunity to provide some additional information. Your Honor submitted a written order on July 12th of 2021 as we were battling back and forth of trying to get the data required in order for our expert to conduct his work. And in that order, Your Honor stated that the state expert is a rebuttal witness and as such should have all necessary and relevant information, which is wording from State v. Reed, from the defense with which to consider all mental health opinions to be offered by the defense at sentencing. In the order, this court also stated to the parties to cooperate. Finally, as was brought up by the defense, there were certain issues that the defense wanted to be off limits for Dr. Schott. And Your Honor stated that the areas which the defense asserted were, quote, off limits were only off limits if such information was not relied upon by a defense expert in reaching an opinion. Since filing this motion, I've had an opportunity to review part of Mr. Wiggins' videotaped interview with Dr. Schott. We've also received defense reports from Dr. Melissa Karin, Dr. Bhushan Aggarkar, Dr. Dale Watson, Dr. Andrew Newberg, Dr. Aaron Bigler. But what was most troubling was in Dr. Schott's commentary and analysis section of his report, and he discusses limitations that were placed upon him, I guess naturally, because of what he did and did not receive. Dr. Schott received the reports of the experts as well as records, historical records pertaining to Mr. Wiggins and his medical and mental health visits in the past, but did not receive raw data or interviewer's notes. And if I may approach, Your Honor, I've got an email that I wish to share with you.
All right.
In this email, Your Honor, Dr. Schott on Monday, July 19th, the first business day after we were in court, and Your Honor ordered that the information be turned over. Dr. Schott writes to Mr. Evans, Mr. Evans, in going over the recently provided expert materials, it appears that I was not sent the following. 1, interview notes. 2, raw psychological test data and computerized testing reports. I would like to review this information. Thank you. Mr. Evans responds the next day, on Tuesday, and says, Dr. Schott, we did not include the information that you request in your email as it is not discoverable. Your Honor, we're here yet again, and I have something tells me this won't be the last time we're here on this, because the defense has not abided by Your Honor's orders. Dr. Schott relied upon what he had. He's a rebuttal expert. And this also goes to a certain extent to the defense's motion. He can only rely upon what he has provided by the defense in their reports, and can only go by what he sees in his interview with Mr. Wiggins. In his interview with Mr. Wiggins, for example, Mr. Wiggins states that the prior experts, the other experts he had spoken to, discussed the facts of the crime with him. Dr. Schott would have known that had he seen the interview notes and the raw data. The reports don't state anything about the facts of the crime that he has been convicted of. Throughout this whole case, since June of 2018, the defense has dragged their feet on purpose as a tactical measure to gain a tactical advantage over the state, and at times disregard what Your Honor has ordered. Your Honor, the state's asking that you put a stop to it. They did not provide what Your Honor ordered. Dr. Schott could not rely upon it because he never had it. Raw data from the psychological test. In particular, Dr. Dale Watson spent 17 hours with Mr. Wiggins.
Let me interrupt you and ask you this question. My order was very specific, and it said essentially that any information that the defense experts relied upon in forming their opinion would necessarily be relevant and necessary for the state's witness.
Correct.
Is there an indication, and of course there are multiple reports that I have just had this morning given to me, there are multiple reports from those expert witnesses. Is there an indication, based on your review, that there was information that they relied upon in arriving at their decision, such as testing data and so forth, that data that Dr. Schott requested that was he was advised were not discoverable? Is there any indication that they relied upon that information in forming their opinions but did not supply it?
Yes, Your Honor. If I may, let me pull two of the reports, please.
All right.
Your Honor, I'll first refer to the report, which is at the heading is Comprehensive Psychiatric Services of Atlanta, which is Dr. Aggarkar. And Your Honor, I would direct your attention to page 4, formal mental status examination. And pretty much in the middle of that paragraph, there's a statement that says, quote, Mr. Wiggins evidenced difficulties on a number of neurological screenings I conducted. Problem one is we see no, other than the Adverse Childhood Experiences Questionnaire, there's no mention of any specific tests that were given, nor reference to any data he relied upon in arriving at his opinions. The report of Dr. Dale G. Watson, neuropsychology, his report, which is very thorough, I must say, beginning on page looks like 16, there's a table that the key for interpretation of ranges, there's test results. It tells each of the tests, yet there's no data to support it. Nor was Dr. Schott provided the raw data from those tests that were conducted. How can the state rebuttal expert do their job if they come in blind? I ask that you, in particular, strike these two experts at a minimum, but the state's asking you to enforce your order and disqualify each of their experts in this case.
Mr. Evans? We're dealing now only with the state's motion to disqualify. We're only dealing at this moment with the state's motion to disqualify, but if you want to go ahead while you're at the podium and address your motion to disqualify the state's expert witness, we can take that up as well. So.
Yes, Your Honor, thank you. First, on the issue of the state's motion, I want to clear one thing up. In their motion in paragraph 10, they make an averment that Mr. Evans, quote, Mr. Evans stated that Dr. Shack will have the underlying raw data and the defense experts, data that the defense experts relied upon, and the state can get it from Dr. Shack. So I want to make one clarification. At no time in that statement did I ever say the term raw data. That's a term of art. That's a specific term. And that was not stated. So I want to make sure that's clear for the record. So there's two issues here that they're claiming. That email is accurate. Dr. Sack emailed and asked for those two things. And I, in good faith and reliance on two cases from this court, State versus Nichols and State versus Scheifelebein, did not provide that information. And as Reed talks about it,
was that before or after my ruling that you were required to provide all necessary information that was relied upon by your expert?
it was after, Your Honor, but I don't view that can't be part of all necessary and relevant information if we have standing precedent like Scheifelebein that says raw data. This was a case where the defense sought it from the state expert, and the court came.
The case you're citing?
State versus Scheifelebein, 230 Southwest 3D, 88 at 149.
All right.
And the court ultimately rules in sum the defendant was not entitled to the raw data under the Tennessee Rules of Criminal Procedure 16 and 26.2 nor Tennessee Rule of Evidence 705. Now, the issue of rough notes, again, goes to even the treatment given to State versus Nichols in Reed. And it's the court says, when we stated, quote, when a psychologist or psychiatrist does not prepare a summary report, but instead relies on extensive memoranda to record not only observations and hypotheses, but also evaluations, such records are discoverable. In this case, and as Your Honor even noted in ruling on the motion that they're referring to, Your Honor referenced that if they don't give reports, then more information would be required. They got summary reports from these experts. In that instance, under Reed, what we've discussed, even in my belief under Your Honor's ruling, in accordance with Reed, did not include rough notes if, in fact, they provided summary reports, which they did.
Test results.
They have test results. They're in their reports. What they're suggesting, they're suggesting that their expert isn't qualified to do the test himself. This is not blind. He should be able. The whole point of this, the frustration from the defense on this point, is either the state doesn't understand the procedure or they don't want to.
Let me ask you something. If you were undergoing a particular procedure or you had some sort of major illness that you wanted to have done and you wanted someone to give you an opinion about it, if all they did was just they didn't look at the test results that you had undergone, but rather they just took someone else's report and didn't bother to look at the test results themselves, would you be confident of their opinion?
Absolutely not, but here's the difference. I would want them to do their own test. And that's
when was Dr. Schott supposed to do his test when the defense did not supply the information that was ordered to be provided within the time frame that was ordered to be provided? As you recall, we had 2 or 3 different hearings on that issue in which you had sought an interlocutory appeal, which is your absolute right, and declined to provide the information despite my ruling because you sought a higher court's review of that. And both of those, the Court of Criminal Appeals and the Supreme Court, denied that interlocutory appeal, which means you were stuck with that. And it was a conscious decision that you made as a trial tactic not to comply with the court's order, but it also meant that the deadlines for these kinds of things were pushed behind, and I think Dr. Schott only had a few days in which to conduct it. How was he entitled, under the Reed notice and so forth, how was he supposed to be able to conduct the type of extensive testing of Mr. Wiggins that you and your experts have had performed if he only had a couple of days to do that? That's what you're arguing is that he should have been able, if he's competent, to perform his own testing. How was he to do that when the delay compacted this case to only a couple of days for Dr. Schott to do anything?
I don't think there's any indication that he wouldn't have had sufficient time, and I don't believe that would be the situation. I think he probably should have done that instead of wasting time doing personality testing on Mr. Wiggins. You know, I mean, that's the thing. He should have. Their expert comes in and does their testing. There's actually ethical obligations and issues with raw data, psychological raw data, that would prevent me from even handling it. It can only go from one expert to the other, is my understanding.
Well, that was the reason I ordered that your expert provide it to the state's expert rather than go through you. I understand that ethical obligation and the confidentiality issues.
And I will note,
interrupted you. I'm sorry.
And Dr. Schott never, to my knowledge, has never reached out to any one of those experts, which he had their information. He would have had to coordinate with them. Typically, I would have seen that done. I would have gotten a call from the expert and said, "Hey, I've gotten contacted by this person."
Now, he did contact you.
He contacted me, and I'm not taking issue with my statement in the email. And Your Honor, we did that in good faith. I did that in good faith based on not only Your Honor's ruling, but existing case law. I mean, he has the ability and had the ability, and if he didn't have enough time to do the test, he could have said so. If that were the issue when he met with Mr. Wiggins, if he didn't have sufficient time, he could have said, "I don't have time." And Your Honor had already opened the idea of, "Hey, you can. We're gonna give him some grace on when he submits his report because he had such a small amount of time."
My problem here is that I specifically remember at the prior pretrial hearings in which I stated that giving this information from the testing supposedly that was taking place to Dr. Schott, allowing him to have that would prevent your client from being exposed to even more potential incriminating statements and so forth of Dr. Schott conducting a bunch of different tests and so forth. Clearly, my indication was that if there were tests to be performed that had been performed that your witnesses were going to testify about, that the very idea of Reed is to allow the state's expert to have the information, necessary and relevant information, to be able to then be a rebuttal witness. And it just concerns me that it appears that the defense in this case has nonetheless resisted providing the information that I more or less specifically ordered them to provide, and it concerns me about that violation or non-compliance at the very least with the court's instructions regarding that information. Now, the remedy that I have is somewhat limited, which would be, as the state is asking me, to simply exclude those witnesses that have relied upon information that was not supplied to the state's witness. I'm certain that you don't agree with that, and that's the rather radical remedy that I prefer not to employ. But my concern is, my ruling was that if a witness for the defense, a mitigation witness, an expert witness, relied upon information, whether it be test results or whatever, that information would have to necessarily go to the state's experts so that they may formulate an informed opinion of their own after reviewing that information. It did not authorize the state to perform its own battery of psychological, well, the psychological part's not a problem, but we're talking about MRIs and CAT scans and other kinds of things that were done.
They have those. They have those. They were provided the MRI. They were provided the PET. They were provided all the imaging, all of that data. They were provided all of that. They were provided a mountain of information. They were provided everything that our experts reviewed and relied upon in forming their opinions, pursuant to your court's order. They got PET scan. They got MRI. They did not get rough notes. And there's not rough notes from the imaging expert.
The email that was introduced says that in going over the recently provided expert materials, it appears I was not sent the following interview notes, and I understand your argument about that. Raw psychological test data and computerized testing reports. And is it your opinion that those were not necessary and relevant?
It's my opinion that, or my position based on Scheifele, that those aren't discoverable. The cycle, and I just want to make sure we're not confusing one thing, and that is the scans, brain scans, the PET and the MRI, those were provided on those on thumb drives and provided to Dr. Shack. Those are there. And they're also attached. All the scans are attached to the back of their reports. So all of the underlying data, I mean, respectfully, Dr. Shack, he can't decipher them. He's not qualified, but he's got them. But the psychological testing issue, the raw data from the psychological test, which is what I understood that email to request specifically. I did not think it included anything else related to the scans because he had those. Those were provided. Those, under Scheifele, I mean, I got the email and researched it immediately. I mean, I didn't just pop back and say no. I researched it on raw data and looked at a holding in Scheifele that's where that was not discoverable. I mean, I don't have the raw data. I've not seen the raw data. I don't have any notes from those, rough notes or interview notes from those experts. I've not seen those. Because, like Nichols said, like Reed said, when you provide a summary report, and as Your Honor indicated in your own ruling, that report is to stand for the information. And it has it gives another glimpse. Now, if our experts had not done summary reports, the psychological experts had not done summary reports, it would have been a different ballgame. So I want to make clear to the court, it was never my intention to be flippant with the court's order, to not comply with the court's order. I did this in good faith based on the existence of the law. And my movement here was going based on Your Honor's statements at the hearing when you ruled, and reading this case and going, there's no way he would have meant that. Because if I would have understood you to mean that, I would have filed an additional motion and said, the raw data can't be part of it. So I didn't understand that. And I'm not scared to file a motion.
I believe you are willing to file any motion you feel like is appropriate. So it's more than that, isn't it? All right, Mr. Evans, let's go ahead and then address your motion in limine to preclude the testimony of the state's rebuttal witness.
Your Honor, if we could have just a moment to address what Mr. Evans said, we will provide.
Yeah, I'm going to give you an opportunity to do that. You want to do that now before we take up? All right, that's fine.
The state is specifically talking about the information that Dr. shot, the psychological raw data from the psychological tests, and the interview notes from those interviewers. Part of being a rebuttal witness is being able to look at the defense mitigation experts to see if they conducted the test correctly, scored the test correctly, was done by an appropriately credentialed person to administer the test. Without that raw data, the state's expert is simply taking it at face value doing a blind review of those reports. In order to give a qualified, thorough report, the state's expert needs that raw data.
All right, let's now address the defense's motion to disqualify Dr. Schatt as the state's expert witness.
Thank you, Your Honor. This is in furtherance of defense filing number 75. It's our motion in limine to preclude testimony of state's rebuttal mental health expert pursuant to the requirements of the 5th, 6th, and 8th Amendments and McDaniel versus CSX Transport and Rules 702 and 703 of the Rules of Evidence. Your Honor, essentially what we're asking for is McDaniel, partially is a McDaniel hearing. Dr. Schacht's expertise, I mean, the state, they were well aware based on the notice of the type of information that was being sought in the mitigation, potentially in the mitigation case. They knew the qualifications, they knew the subject matters. Frankly, there's brain scans, MRIs, things of that nature, PET scans, that Dr. Schacht opines about in his report that, frankly, it'd be our position he's not qualified to opine. And he also goes on, even on the psychological testing side or the diagnosis side, and has a litany, as Your Honor has seen in the motion. I went through several examples of words, you know, if, maybe. Does not do a full diagnosis of personality disorder, but essentially says, you know, I'm not quoting, but he might have one or he could have one. That's the type of information that's in his report. Dr. Schacht, at one point on page 2 of the motion, we've got a section that says, in my opinion, Mr. Wiggins reported a documented history, his clinical presentation and report of subjective experiences in my interviews and his responses to the International Personality Disorder Examination converge in demonstrating the presence of personality disorder with prominent borderline and antisocial features. In connection with his personality dysfunction, Mr. Wiggins also demonstrates in my examination an extraordinary self-reported propensity towards a wide range of violent thoughts. And then he has relied upon 2 assessment tools, one of which is the Firestone assessment of violent thoughts assessment. Take several issues with this. One, Your Honor, it's our position that he's failed to, in his report, doesn't indicate that he's providing a diagnosis. And it borderlines on, or really is more of speculation than it is him coming in and assisting the trier fact.
Is he required to give a diagnosis? He's a rebuttal witness, basically giving his impressions about the situation. He would be, under the rules, allowed to sit in the courtroom as your witnesses testify, and at that point he may give an opinion based upon what he's heard. He may give, but there's no requirement that I'm aware of for a rebuttal witness to actually give a diagnosis, is there?
So, and no, I'm not suggesting that there's some blanket requirement, but I don't think what he's allowed to do is come in and go, for a couple of reasons. This personality disorder issue. I don't think he's allowed to come in and go, you know, I don't think it's what that guy said, but you know what it might be? It might be personality disorder.
Well, it sounds to me like what you're actually objecting to are the things he's going to say, not necessarily his qualifications to render opinions about certain things, but that you're saying that he's not necessarily qualified to give testimony in rebuttal to some of your experts,
That's right.
Although he's certainly qualified from his degrees and so forth as an expert in some fields. But it may be that you have objection to his testimony as to certain elements of the mitigation proof. Would that be accurate?
That's correct. The other issue with personality disorder is no one, you know, if we're talking about him having a narrowly tailored, that this is rebuttal. He's only allowed to rebut. None of the mitigation experts from the defense did personality testing, mostly because it's not reliable. and not highly respected in the field. But nonetheless, he did, and he's going to want to come in. A large portion of his report is this discussion of personality.
We're just having a discussion.
Yeah.
I'm sorry for
That's okay.
continually interrupt you, but in my cursory, very quick reading of his reports, I think part of what he does is to indicate that there are certain statements made in these experts' reports that you are promoting, in which he, in his interview with Mr. Wiggins, finds contradictory information from Mr. Wiggins, or in the documents that he's been provided, that his information is contradictory. I understand what your argument is about the psychological testing that reveals a personality disorder, because, as you correctly point out, he would be a rebuttal witness to whatever the defense witnesses testify to. And if that's not directly in rebuttal, and which I'll necessarily have to hear some of that to be able to determine whether that is in fact rebuttal, then if it's not rebuttal to what the state's experts offer, then it may very well be that he will not be allowed to testify on those issues. But again, your motion is to disqualify him entirely as a witness, and that's what I'm trying to determine. I understand you may disagree with his conclusions. You may argue that they should not be given weight, but your motion to disqualify is based on the fact that he's saying things that apparently you think that are not really diagnosis or accurate. So that's what I'm trying to understand, what the basis is for disqualifying.
The disqualify outright. Well, and I will say this: it's all there. We believe they're all interconnected. But the issue that brings it to the forefront for today's purposes is the scope of his, and this was the fear early on when we were litigating Reed and putting those safeguards in place, and what information he would try to obtain from or during or testing he would do, those types of things to make sure they were complete, like we were asking for submitted questions, that sort of thing, prior to his interview with Mr. Wiggins. And in this instance, the concern is that he has now went in and made opinions based on information that was outside the scope of information that was relied upon by our experts. Section 3 of my motion talks about
So,
that.
in other words, if your expert had given him the raw data of their psychological interview and testing, then he would have had that to rely upon without having to ask Mr. Wiggins any additional questions, or are you saying something different?
I'm saying something different. I'm saying he goes into detail in his report about prior criminal and bad behavior of Mr. Wiggins. I mean,
Which he's not yet been allowed to testify
Right.
to. And again, that goes to the issue of what's he going to be allowed to testify to at the hearing versus in rebuttal to the witnesses. It would seem to me that unless there's some witness for the defense in mitigation that testifies about an issue that directly relates to what Dr. Schott has put in his report regarding the history or the violent history of Mr. Wiggins, if there's nothing that's brought out by the mitigation experts about that, and there's no correlation, then it would seem to me pretty obvious that that would not be a proper rebuttal for him to just go beyond rebutting anything and go beyond it. But again, it doesn't go to his qualifications, it goes rather to the scope of his testimony and what he will be allowed to testify to. That just seems to me to be the way I see it. And what this is all really going to be boiling down to is that we may have to have a jury out hearing to hear some of these things, both from your witnesses and then after your witnesses have testified, if they're allowed to, based on the state's motion, then we'll entertain Dr. Schott's testimony, and then we'll determine whether or not portions of it or all of it or none of it should be allowed. So.
And I agree with Your Honor wholeheartedly. It's going to take an evidentiary hearing to flesh out the issues.
Do you have your experts here today in the event that we were able to get started on that?
No, I mean, like for this, we would need Dr. Schott. So
I think he's going to have to necessarily hear your witnesses before we have that jury out hearing about that situation. In other words, what I'm saying is he would have to necessarily, under the rule, be allowed to sit through the testimony of your experts. And under the rule, as a rebuttal expert, he can hear their testimony, hear what they have relied upon in forming their opinion, determine whether or not that, in my opinion, then we'll need to necessarily hear whether or not he was supplied with that necessary and reasonable information that they relied upon, And if not, at least he will have an opportunity to hear that. We may have to have that hearing before I determine whether or not to allow your witnesses to testify if they were in contravention of my order beyond just I understand what you're saying, and I'm going to review that case that you're citing. But my concern is that in front of the jury, if your witnesses are allowed to testify and produce this information that Dr. Schott was not given in contravention of my order, which I'm not saying that is the case, I'm just saying if that were the case, then we've allowed the jury to hear matters that maybe they shouldn't be hearing. So I'm concerned what I'm thinking in terms of now, and I want to take a recess to review that case. We may necessarily have to have a hearing in which all of your witnesses testify and give us the basis upon which they form their opinion and what they're relying upon, with Dr. Schott in the courtroom listening to that so that he has an understanding of what they're relying upon. And then at that point, he can testify about whether or not, what his opinions would be, and then you have an opportunity to object to it. So that's just throwing that out as a procedural possibility. All of this would, in my opinion, have been resolved a lot easier if all of that information had been supplied, but I understand your position, and you're representing your client. Is there any other basis that you want to raise for the record about your motion to strike or to exclude him as a witness?
Your Honor, the only other issue, and this goes back to the Reed issue, is in the reaffirmance. The only other issue is that, of course, all this other information is now, it's something that it would affect how we proceed, what he's allowed to say, whether he's allowed to say it, certain issues in here. If he were to be allowed, even though our experts didn't go into any kind of prior criminal or bad behavior, if he were be allowed to go into that, it affects decisions that get made about strategy going forward, for the penalty phase of this case. So that's one of the issues. Now, I'm not disagreeing with the court that an evidentiary hearing as to Dr. Schott is appropriate and necessary before he be allowed to get on the witness stand because of the issues, our specific issues. A Dauber hearing is essential, or a McDaniel hearing essentially, is what we're asking for. And I understand the court's suggestion, as it relates to the defense's experts. But again, these are if he needed more time to do the test. If he wanted to do the test, he could do the test.
You asked for a continuance, which would have given him more time, but I didn't grant you a continuance. But all right, let me hear from the state. Now we're just addressing the defense's motion to disqualify Dr. Schott.
Yes, Your Honor. One of the first things that Mr. Evans stated was that the state knew the defense expert qualifications and insinuating that we should have gotten different experts based on the qualifications we knew. The problem with that, though, Your Honor, is we never received the CVs for the defense experts. We have not received them. The only one we received was from Dr. Bradley Freeman, who did not provide a report, but was in the initial round of experts noticed to us a couple years ago. The remaining people on that list, we don't have it. Your Honor, in the motion, it's the state's opinion that under the guise of a McDaniel versus CSX and qualifications, the defense is simply trying to pick apart Dr. Schott's report to keep him from testifying to begin with before, without context as to what their experts will state and what we'll be able to rebut. But
you would agree, would you not, General Wyatt, that the purpose of a rebuttal witness for the state on the issue of mitigation expert testimony is to rebut that testimony and not to offer testimony about matters that are beyond the rebuttal of what the state. In other words, the defense is arguing that Dr. Schott's report, which the report itself is not necessarily admissible, but I'm saying his testimony should not be allowed to go into things that he asked of Mr. Wiggins in his interview with Mr. Wiggins that were beyond what the defense witnesses. How do you address that?
The state agrees with you, Your Honor. But this kind of goes back to our previous motion that their experts submitted summary reports. In particular, with their psychiatrist report, there's only one test that's listed. We don't know what tests were given and then simply not produced because they didn't like what they saw.
And during cross-examination of those witnesses, you would be able to, would you not, to cross-examine them about the reports that they're not, I mean, the basis for their opinion and the lack of any sort of probative information obtained from any sort of testing. If they're not relying upon it, then why did they do it? And if they did rely upon it and it wasn't produced, then, obviously that's an issue. But I guess I'm saying is that seems to me that that's a cross-examination issue for the state to cross-examine the witnesses, and it goes to the credibility of those witnesses rather than the admissibility of it.
You're giving away our strategy, Your Honor. One of the main things that is troublesome to the state, on page 7, there's a list of points that the defense wants to have inadmissible. The problem is they're not exactly what's actually said in Dr. Schott's report. For example, on the first one at page 8, the motion states, whatever Mr. Wiggins' incredulous stories as a child represented, there is no clear indication it was psychosis. Report at page 8. Here's what it actually says. Whatever these stories represented, there is no indication it was psychosis, as Mr. Wiggins' reported mental status at the time was benign. That's inaccurate. It's an accurate statement. On page 10, the motion states Mr. Wiggins' account of his high school grades, quote, would appear preposterous, but it could, quote, could actually make psychological sense if he has a severe dissociative disorder, end quote. What it actually states is the last paragraph, or last sentence of the third paragraph on that page. When the worker confronted Mr. Wiggins about his school failure, he then told the story that the failing grades were a mistake. He claimed that for some unknown reason he had decided to sign a different name on his school papers. There's a superscript taking it down to a footnote, number 4, that says, on its face, and under most circumstances, this story would appear preposterous. However, this could actually make psychological sense if Mr. Wiggins has a severe dissociative disorder as discussed elsewhere in this report. And that goes on throughout the motion. And I could go on and on, but it'd be wasting time. The point is, Your Honor can't take that motion on its face because it's not what is actually said in these reports. The defense is simply trying to disqualify and remove his testimony based on what they want it to say as opposed to what it actually says.
Anything further, Mr. Evans? All right, we'll take a recess and allow me to review the case that has been cited and to review some of these reports. I'll come back and I'll give you my ruling as soon as I'm able to do so. The jury is not arriving until 11. Now, anything further? Did you want to address anything, Mr. Crutch?
Mr. Evans and I could address the court off the record when you adjourn.
All right. What I'm considering doing, because this all goes to the mitigation phase, and we've still got to get through the state's proof first, and it would seem to me that may be possible as soon as when the jury arrives, even if I haven't made a complete ruling on it at this point, I'd like to go ahead and take care of that, and then we'll see where we are regarding these issues. So, all right, we'll stand in recess, and I will see you two in chambers.
All right.
Recording in progress.
All right, let me first tell you that the process that I'm going to employ, but we'll get the defendant out first. You may. All right, in regard to the two motions that we're dealing with expert witnesses, let me tell you that my decision is as follows. I'm of the opinion that the information that is sought in this case by the state's expert witness is permissible under the rules. I know that the defense has, in good faith, operated on the assumption that these issues are not discoverable under the rules of criminal procedure and the rules of evidence. However, as was pointed out in the hearing yesterday, our Supreme Court has held that in a death penalty case, especially as to the sentencing, those rules are not to be strictly applied. That was the reason that we were able, based on the Hester case yesterday, to employ the 4 alternates to reserve them for possible use in the sentencing phase if there was an issue. In addition to that, I've reviewed the case that Mr. Evans has cited, the State versus Schiefelbein case, which is what the defense is relying upon about the notes not being provided. But I would also point out that in the State versus Eugene Hodges, Henry Eugene Hodges, our Supreme Court in a death penalty case, or the Court of Criminal Appeals rather, in a death penalty case, had also provided that the trial court has the discretion to require that the underlying facts and data used by the experts to formulate the opinions to be provided to the other party, and that's under Rule 705 of the Tennessee Rules of Evidence. And that the court further stated that there's a general rule, a trial court will require disclosure of the underlying data of the expert's opinion when the court believes that the party opponent will be unable to cross-examine effectively, and the reason for such inability is other than the prejudicial nature of such facts or data. It is my opinion that the information that I had previously ordered on multiple occasions to be provided to the state's expert is in compliance with the Reed procedure that our Supreme Court adopted. The Reed procedure differs from the rules of criminal procedure. It is a specific procedure that our Supreme Court set out, whereby in death penalty cases where the defense intends to introduce mitigation expert involving testimony involving mental health issues, that they are required to give notice of that fact to the state, and then the state has the election to have their own mental health expert witness. And in this case, they are to then cooperate and supply the state's expert with all necessary and reasonable information. It is this court's opinion, as it has been from the very beginning, and the hypothetical I posed to Mr. Evans is that if you're going to ask an expert to render an opinion, not giving him the full information upon which testing was done and so forth would in fact be render his opinion to be meaningless. And I understand the defendant's position is that they don't think that it's necessary for them to turn it over and it's not discoverable. This court is of the opinion that my order is in fact enforceable under the rules of evidence as well as under the Reed procedures, and therefore I'm ordering that the defense expert witnesses supply the information Dr. Schott has requested. If there are notes that are requested, I will allow you to provide those notes to me to examine in camera, because that is also something that the Schiefelbein case court indicate that it might be better for the court to review some of those materials in camera, and if the notes are the issue, then I would do that. But I would just simply point out that I think it was Dr. Watson that was giving his opinion. Let me find it. Yeah, Dr. Watson gave his opinion, and in it, he gave us a listing of all of the tests that were performed. And I think the listing of tests that were performed by Dr. Watson included 2.5 pages of different tests. And again, to formulate his opinion, obviously, those tests would have been something that would necessarily have to enter into his opinion, or else there was no reason to perform those tests. But more importantly, that's the type of information that I believe should be provided to Dr. Schott for the state, and therefore my ruling is that the state's expert witness will be provided with all of that information. If there's any information in the notes that they think is something that shouldn't be provided, then they'll need to submit that in camera for me to review, and I will make my ruling accordingly. Based upon that, I'm reserving the state's motion to exclude testimony of the defense mitigation expert witnesses until such time as I see that they have complied with the court's order. If they fail to comply, then they very well may be excluded from testifying. If they comply, then they will be allowed to testify. Dr. Schott will be entitled to review that information, and we'll have an evidentiary hearing before he testifies to determine whether or not his qualifications are such that would allow him to do so. I will point out that Dr. Schott is entitled to testify within his range of expertise regarding the issues that are in rebuttal to the mitigation experts of the defense. That is his purpose. But there are certain things that have been pointed out in his report, for example, that may go to the issue of the accuracy of the testing and opinions of the mitigation experts that I'll not go into here, but may come out during the hearing. And it's not his report that's going to be introduced before the jury. His report is just, his statement of what is involved and what he's arrived at in an opinion. But his testimony will be what's essential, and that's where we'll have to have a jury out hearing to determine what his testimony will be. So that's my ruling on those issues, and we'll reserve anything further on those two until after we've gotten that information passed on. But I will state that the information from the defense experts to Dr. Schott needs to be within the next 24 hours. So,
And Judge, to clarify your ruling, does that include the raw data behind the testing?
it does.
Okay.
All right. With that, then, we are ready to bring the jurors in. We'll bring in the 4 alternates first and then the other 12. And we're going to, as we discussed in chambers, my understanding is the state will make its opening statement on the sentencing phase, but the defense is going to reserve their opening for a later time, and we'll make that explanation to the jury when they arrive. So. Good morning. We're going to bring the other 12 in before we get started. Thank you. Good morning again, ladies and gentlemen. Let me explain to you that this will be the beginning of the sentencing phase of this trial. And in a sentencing phase, both sides have the right to make an opening statement to you about the issues that are going to be presented to you in this phase of the trial. The state will make its opening statement now. They will put on their proof first. The defense will have the opportunity to put on their proof second. So I have allowed them to reserve their opening statement to make it to you after the state has rested their proof. So the state will make an opening statement, they'll present their proof, then the defense will have an opportunity to make an opening statement and present proof as we go along. So please understand that they're not waiving it, they're just going to reserve it. All right, General Crouch.
Good morning, ladies and gentlemen. I want to again thank you for your patience as we go through this process. As the judge said, this is the sentencing phase, and I would ask you as the jurors in this case to again pay specific and close attention to the evidence and testimony of the witnesses. I will be very brief in this opening statement. The state intends to prove 5 aggravating factors. Those factors include 1, that the defendant was previously convicted of a felony whose statutory elements involve the use of violence to a person. 2, that the murder was especially heinous, atrocious, or cruel in that it involved torture or serious physical abuse beyond that necessary to produce death. 3, the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution. 4, the murder was committed against a law enforcement officer engaged in the performance of his official duties, and the defendant knew or reasonably should have known that the law enforcement was in fact engaged in his official duties. And 5, the defendant knowingly mutilated the body of Sergeant Daniel Baker. Thank you.
All right. The defense has, as explained, reserved their right to make their opening statement, so the state may call its first witness.
Thank you. Your Honor, the state calls Dr. Feng Li.
Dr. Feng Li. We're glad to have such an impressive podium, but it weighs about 300 pounds. So as you see these 2 strong young men trying to move it around, just understand that we've advocated trying to put it on wheels that might make it easier to do that. So.
You would stand right here, face the clerk, please.
Do you solemnly swear, affirm that the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning, Doctor.
Good morning.
For the record, are you Dr. Feng Li?
Yes,
And Dr. Li, could you again say your name for the court reporter and spell it?
Feng Li, F-E-N-G-L-I.
And Dr. Li, how are you currently employed?
I'm currently Chief Medical Examiner for Metropolitan Nashville and Davidson County.
Okay. And Dr. Li, just briefly, what are your medical qualifications?
I had a medical degree from China, PhD from University of Louisville, and a law degree from Nashville School of Law. I had my residency training in anatomic and clinical pathology in Philadelphia, forensic pathology fellowship training in Philadelphia.
Okay. And at this point, Your Honor, we'd like to move what's been previously marked as trial exhibit number, I believe, 217, Dr. Lee's CV into evidence for this hearing.
All right, for the sentencing hearing, Dr. Lee's CV will be marked as an exhibit for this hearing as well.
Exhibit 1 for this hearing,
Yes.
and it was exhibit 247 in the jury trial.
The curriculum vitae.
Oh, that one, okay, never mind.
And Your Honor, at this time, we'd also like to tender Dr. Lee as an expert in forensic pathologist.
All right, let's just, for clarity's sake, let's just continue using the same exhibit numbers, and we'll just
Okay.
show they're already exhibits to the trial, so what is the,
Did you use the same
yeah,
number?
what is the exhibit number?
217?
I believe it is 217, ma'am. And Your Honor, we'd like to tender Dr. Lee as an expert in forensic pathology.
Any questions? All right, Dr. Lee will be qualified as an expert in forensic pathology.
And Dr. Lee, I'm going to approach and hand you what's been marked as exhibit 247. Do you recognize what that is?
Yes, this is a copy of my autopsy report.
Okay. And Doctor, you've previously testified about this autopsy report, but I'm going to go over a couple different questions with you again, okay?
Okay.
Now, Doctor, just briefly, how many gunshot wounds were there to Sergeant Daniel Baker?
Total 6.
Okay, thank you. And we have gone over those in great detail, and we're going to make this as the state's next exhibit, which I believe is actually going to be 247. And Doctor, if you would please, is the document on the screen the same document that you have, the autopsy report?
Yes.
Okay. And in your autopsy report again, does it go over and chronicle all 6 gunshot wounds along with other injuries?
Yes.
And if we could please focus down on, I believe it's going to be page 5. We're going to talk about the thermal injuries. Dr. Lee, could you again go over what the thermal injuries were to Sergeant Daniel Baker?
So thermal injuries for laytime basically is like a burn. And there are several classification or, injuries associated with thermal injuries. First one is the area, how big it is, and the second is how deep it is. For the depth of the thermal injuries, usually there's a 1st degree, 2nd degree, and 3rd degree, sometimes even 4th degree. And for the areas, you'll say the rule of 9s or, that type of thing. So a rule of thumb is your one hand is about 1%.
Okay, thank you, Doctor. And in this case, could you go over a little bit more about your finding of the carbon monoxide and soot in airways?
Right. Carbon monoxide is a byproduct of the burn. And when especially these materials burn, any complete combustion of the material will generate these toxic fumes. Carbon monoxide is one of them. And soot is also will be a byproduct of the fire or burn. And in the enclosed area, if there's a meaningful breathing of this byproduct, especially carbon monoxide or soot, then they will be deposited in the airways, including the trachea, bronchi, and so on. And the carbon monoxide level will be detected in the blood. And in this case, there's no soot in the airways. There's no carbon monoxide detected in the blood.
Okay. So, Doctor, does that mean, based on your medical experience and professional opinion, that at the time of the burning, that Sergeant Daniel Baker was already deceased?
Right.
Okay. If we could, please, Mr. Etheridge, have the first image up. I'm going to hand you what's been marked as Exhibit 241. And Doctor, the image on the screen, is that the same image that you see?
Yes.
And could you describe this?
Right. These are the brown discoloration and the black and brown areas. These are the burns on the skin. and mainly on the right side of the torso and buttock area.
All right, thank you, Doctor. We'd move that photo as the next state's exhibit to the sentencing hearing. I'm going to hand you another photo. Do you recognize that photo, Doctor?
Yes,
And what is this?
the same, the discoloration, brown and black areas on the torso, right side of the torso and the right buttock area. These are the burn on the skin.
All right, thank you. And we would move that photo as the state's next exhibit. And let's see what this is. I'm going to hand you what's been marked at trial as 243. And doctor, do you recognize what that photo is?
Right, these are the uniforms and the clothing associated with the victim, and they are partially burned.
Okay. Can we move that as the next state's exhibit, please? I'm handing you what's been marked as 244. And do you recognize those photos?
Yes, on the other side of the clothing,
All right.
and they are partially burned.
And, Your Honor, we would move that as the next state's exhibit. Dr. Lee, in this case, we discussed previously when you testified. Have you gotten a chance to review the body camera footage in this case?
Yes, I did.
Okay. And in the body camera footage, do you recall seeing multiple series of gunshots?
Yes,
And in that, after the first round of gunshot fire, did it appear that Daniel Baker was still alive?
yes,
And how do you know that he was still alive?
because he screamed, and later he moaned, and he had a sound of breathing.
Now, doctor, you said that he ran. Did you see him upright in the video?
Yes, he ran first and then collapsed.
And after he collapsed and he was on the ground, did he appear to be breathing?
Still moving and still breathing, and some noise on that.
And after the last series of shots, which may have been to his head, is there still potential that he would have been alive?
Actually, when I examined the video, and I still can hear some noise associated with probably breathing after all the shots fired, and for a short period of time afterwards.
And doctor, based on your other testimony, the shots to Sergeant Daniel Baker's flank, would they have been severe and fatal shots?
Yes,
So there's potential that he could have died just from those shots
yes,
and all of the extra shots as well.
yes.
We'll pass the witness, Your Honor.
No questions.
Thank you, Dr. Lee. You may step down and we'll release you from your subpoena. State may call your next witness.
Your Honor, the state would call Assistant District Attorney Jessica Bourne.
Will you stand right here, face the clerk, please, one?
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, self you got? Yes, I do.
Good morning.
Good morning.
If you would, state your name and spell it for the court, please.
Yes, Jessica Bourne, Jessica-Bourne.
Ms. Bourne, what do you do for a living?
I'm an assistant district attorney for the 21st Judicial District, which includes Williamson, Lewis, Hickman, and Perry County.
And how long have you been with that office?
I've been with the office since 2009.
Since 2009, what sort of courts have you practiced in?
I've practiced in General Sessions Court and Circuit Court. Since 2011, I have been working domestic violence cases in the General Sessions Court as well as Circuit Court up until about 3 years ago, where I primarily practiced in our Circuit Court doing felony domestic violence cases and light cases as well as other general cases.
Thank you. Your Honor, may I approach the witness?
You may.
Ms. Bourne, do you recognize that document?
Yes, I do.
What is that document?
This document is a judgment out of our Circuit Criminal Court in Williamson County regarding the defendant, Stephen Wiggins, where he was convicted of aggravated assault on December 15th of 2017.
Was he convicted as he was charged?
Of this count, yes.
All right. Your Honor, may I approach the witness?
You may.
Your Honor, we'll make the certified copy of the conviction the next exhibit to this hearing.
All right, welcome as the next exhibit.
Now, General Bourne, if you would turn to the section of this. Well, first off, do you recognize the document that you have?
Yes, this is a transcript of the plea.
And this is the plea for which we entered this last exhibit?
Correct, for the aggravated assault on December 15th of 2017.
Did you handle this case?
I did.
If you would turn to, I guess, the recitation of facts in this transcript, which I believe is on page 29, in particular for this count.
Mr. Wyatt, hold on just a second. Let's get straight on our exhibit numbers, because some of these are new documents that have not yet been exhibited. Ladies and gentlemen, we have a number of exhibits. What we're trying to do is to make sure we have them in the correct order. Since these were made exhibits, we're keeping the original exhibits in their order that they are offered. But do we need to offer them as an exhibit for this? Let's just mark them as the next numerical exhibit for the entire trial, which would be what?
248.
248 would be the exhibit number for those of you in the jury who are keeping up with them. 248 would be the collective exhibit of the charge of the judgment form that was shown. All right, so this is now the transcript, correct?
Yes, Your Honor.
All right, I apologize for interrupting.
General Bourne, it looks like on page 29, beginning at line 11, does that appear to be a recitation of facts for this conviction?
Yes, sir.
And is this you speaking?
It is.
If you would, General, please read the recitation of facts as it pertains only to this conviction.
So starting at line 11, moving on to case ending in 385, the summary of the state's proof would be that on July 6th of 2016, Dixon County Sheriff's officers, as well as Fairview police officers, responded to the Fairview Inn located here in Williamson County, Tennessee, on a call for the defendant, Stephen Wiggins, holding a female, the victim in this case, Tiffany Beach, at knife point in a room at the Fairview Inn. Officers were able to gain entry into the room at the Fairview Inn, where they did see the defendant holding a knife, and the victim in this case, Tiffany Beach, was cornered in the hotel room. She was clearly in distress and in fear of imminent bodily injury. And that would essentially be a summary of the state's proof, ending in case 385.
Thank you, General. If we could, Your Honor, make the transcript the next
All right,
exhibit.
transcript would be marked exhibit 249.
General Bourne, do you remember this case?
I absolutely remember this case.
Why do you say that?
I will carry the...
You may. You want this on the record? Yes. All right. Hold on. All right.
Object to the entire transcript being entered as an exhibit. The only relevant parts of it that are necessary for the purpose of this hearing are the factual recitation. It actually goes into other counts as a part of that instrument.
We will redact that transcript. Those portions of the transcript that only relate to this particular offense, please, will be omitted. Ms. Lewis will need to make some changes to that transcript or to the redactions to the transcript. All right. You may proceed.
May I continue, Your Honor?
You may.
I'm sorry.
Yes, I'm sorry. Go ahead.
So how do you remember this case?
Objection.
Ladies and gentlemen, step across the hall if you will, please.
We'll wait just a moment for conversing.
Just reminding you that we have to keep you separated from the other four so that there's no communication between you. Right. Mr. Evans, what is the basis for the objection?
Her recollection of this case isn't relevant to the aggravating factor. They've established the aggravating factor. Her perceptions, recollections, or otherwise are absolutely irrelevant.
General White, in the absence of the jury, would you ask the question of this witness and let me hear her answer so that I can determine whether or not it would be admissible?
Yes, Your Honor. Why do you remember this particular case?
I remember this particular case because Mr. Wiggins was in our jail for 13 months while we searched for the victim in this case. Tiffany Beach, we had our investigators searching for her that entire time in hopes that we'd find her and be able to pursue fullest extent of prosecution in this case because we were aware of Mr. Wiggins' history. We were aware of his history of violence. We'd worked with Dixon officers and established that. And it's every prosecutor's worst nightmare when you can't produce a victim that you have to have in order to proceed on a case to trial. We have to follow the rules of evidence, follow the law. And after 13, 15 months, we resolved the case on a plea agreement. And it's your worst nightmare when less than 5 months later, someone's released from jail and, in this case, murdered Sergeant Baker. I'll carry it with me my entire life.
That's it, Your Honor.
Mr. Evans?
Your Honor, he's confined to an aggravating circumstances as part of his case in aggravation. Aggravating circumstance specifically states the defendant is previously convicted of one or more felonies other than the present charge of statutory elements involved in use of violence of the person. They've proven that. They did that to the judgment, to the factual recitation. It was entered into evidence. Her perception, how this stuck with her, is inflammatory, it's unduly prejudicial. It's also not logically relevant. It has nothing to do with whether or not he was convicted of that crime. They've proven that. And it will allow us before the jury to be committed.
General White, let me hear from you. Mr. Evans correctly points out that the convictions, or what is the conviction for a violent felony, is what is the aggravating factor. And while certainly Ms. Bourne has the opportunity and certainly has every right to have her opinions about the situation, it would appear to me that her beliefs and the background she gives to the situation would go far beyond establishing the aggravating factor of a prior violent felony. You have some reason why that would be admissible?
Your Honor, in TCA 3913-204, in Part C, the statute states that the state or the defense may put on evidence concerning the circumstances of the facts, and the defense may have a chance to rebut, and that's simply what we're putting that in under that.
Facts, the circumstances and the facts
Yes.
of the case, and you're talking about the aggravating factor of the prior violent felony.
Correct. It pertains only to that particular aggravator.
Well, I think the circumstances and the facts have to do with what was testified to by District Attorney Bourne about the circumstances that occurred and what the soliloquy was about, the events that led to the conviction, the factual basis for the conviction. Those are the facts and the circumstances. The information that she has now offered that goes beyond that and talks about, and it describes, her consideration of what happened after he was released from jail and so forth, and that's, I know that's every prosecutor's fear is that sort of thing happens, but my concern is that goes far beyond the facts and circumstances. The issue is to prove the prior violent felony, and that has been proven. The facts and circumstances were elicited in the statement that she gave and that she read from the transcript. And unfortunately, I'm afraid that going beyond that may create an issue that we're trying to avoid. So I'll have to sustain the defense's objection rather. General, I know it's how you feel, but I'm of the opinion that we are not going to be able to allow you to state that in the presence of the jury.
Yes, sir.
All right. Then we'll bring the jury back. Ladies and gentlemen, as I told you all along, there are times when I have to make certain determinations about the admissibility of certain evidence, and I have considered the question that was asked by the state and the objection, and I've ruled that meeting the aggravating factor standard, that the evidence that's been introduced through this witness is sufficient, and I've therefore excluded anything beyond that. So, all right, Mr. Wyatt.
Thank you, Your Honor. General Bourne, last thing. Do you recognize Mr. Wiggins here in the courtroom today?
Yes.
If you would describe what he's wearing, please.
Yes, he's seated over at the table to the left with a blue button-up shirt on, glasses, dark facial hair.
Thank you. Let the record reflect that she's identified Mr. Wiggins.
Record will so reflect.
Pass the witness, Your Honor.
Thank you. Cross-examination?
No question.
Thank you, General Bourne. We will release you from your subpoena. You may stay or you may go.
Thank you, sir.
State may call your next witness.
State calls Nathan Neese.
You solemnly swear from the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am, I do.
Judge, may we approach?
You may. Ladies and gentlemen, this next witness is going to take a little bit of time. You may remember, I think he was on the stand for about 2 days the first go around. So what we're going to do is we're going to go ahead and break your lunches here. So we're going to go ahead and break for lunch, and then we'll come back as soon as lunch is over. We will be in recess for lunch. All right. Stanley, how long is it? Do we anticipate it will take for lunch? Well, under the circumstances with the statements that we've made and the discussions that we've had regarding the proof that we're going to be offering today, let's just take an hour for lunch today. So we'll be in recess until 1 o'clock.